of the estate of Kate Denning versus Zeta Landonu, plaintiffs.
Good evening, Your Honor. Joseph Cruz and Kevin Ortega on behalf of the plaintiff. Additionally, Your Honor, after the defense has finished their introductions, we have a few housekeeping matters and motions in limine we would like to address.
Okay, defense?
Juliana Morgan and Shaheen Hashemian on behalf of the defendant in this case, Zeta Landonu, and we also have a few housekeeping matters and motions in limine to address.
Okay, let's start with the housekeeping. Mr. Cruz?
Yes, Your Honor. Do we have permission to keep water at counsel's table?
That's fine.
And Your Honor, is the court going to constructively invoke the rule of sequestration?
What does that mean?
The witnesses would leave the room, and this would allow them to stay if it's constructively invoked.
Okay, that's fine.
And Your Honor, may we freely move around the well of the courtroom throughout the trial?
Yes.
And Your Honor, for the purposes of the trial today, may we argue sidebars constructively from where we're standing?
You may.
Thank you, Your Honor. And would Your Honor like us to swear in the witnesses? Would Your Honor like to swear in the witnesses, or shall we presume that they've already been sworn in?
Let's presume that they've been sworn.
Yes, Your Honor. And does this jurisdiction follow the one advocate, one voice rule?
Explain that to me.
It would be the advocate that's doing a direct or cross-examination would be the one that would have to object when there's a examination going.
Okay, understood. We'll acknowledge that rule.
Yes, Your Honor. That's it for the plaintiff, Your Honor.
Were there any additional housekeeping matters for the defense?
No, Your Honor.
No? Okay, let's move on to motions, please.
Yes, Your Honor. Pursuant to the Florida Rule of Evidence 90, 401, and 404, the plaintiffs seek to exclude any mention or testimony of Sergeant Bell's prior instance of meeting Mr. Dornberg's father. By way of background, Sergeant Bell is the one who investigated the incident at hand today, and while he was conducting the investigation, he interviewed one of the defendant's witnesses, which is Mr. Dornberg, the treasurer of Zeta Lambda Nu fraternity. We are asking to exclude this because at the time, Sergeant Bell did not have any knowledge that Mr. Dornberg was in fact related to his father, and they had a prior incident run-in, and Sergeant Bell has anger towards Mr. Dornberg's father for not allowing him to enter the fraternity previously.
Defense?
Your Honor, as stated, Sergeant Alexander Bell did have a previous relationship with Andre Dornberg's father that angered him, and that relationship can go directly to bias. Therefore, we find that it would be relevant today for this trial and should be allowed in.
I don't think I have enough foundation to know whether or not it's relevant here. If it does go to bias, I don't want to rule it out right away now. So what I'm going to do on that is reserve ruling. So either on direct or cross-examination, if this is something that's going to come up, make sure it's addressed by with the court first. So my ruling on that is reserved. Any other motions?
Yes, Your Honor. Pursuant to Florida Rule of Evidence 90, 401, and 403, the plaintiffs also seek to exclude any mention of evidence or testimony of Ms. Denning's use of marijuana or pot brownie. By way of background, Ms. Denning was intoxicated, or rather, allegedly drank during this event, and the defense raises a affirmative defense where once you're above a 0.08 alcohol blood level and the alcohol causes the injury, the plaintiff is at fault and cannot recover. The defense would seek to use this evidence in order to prove that she was intoxicated and inebriated by drugs or alcohol at the time of the event, but there's already enough evidence in play that there is alcohol already, rather there's toxicology reports already available. If this evidence were introduced, it would prejudice the jury seeing Ms. Denning in an unfavorable light that she consumes marijuana and does illegal activity.
So is your argument that are you talking about the toxicology report or any mention of it?
No, not the toxicology report, Your Honor, but any mention of marijuana or any testimony or evidence of marijuana, or rather the pot brownie being introduced through testimony or through the toxicology report.
So is your main argument here that it's cumulative?
Not only is it cumulative, but it would further prejudice the jury, and because it is cumulative, the probative value of this evidence is low, and it would not help the jury find any fact.
Okay, defense?
Your Honor, if I may proffer, Chris Bloom will testify here today to Ms. Denning's usage of marijuana. Furthermore, as stated, there is a toxicology report that shows she had marijuana in her system. The defense has asserted an affirmative defense that states Ms. Denning was negligent and therefore caused her own injuries. Her drug use and alcohol use that night goes directly to that.
Yeah, I tend to agree with the defense here, so I'm going to, deny your motion. Any others?
Plaintiffs do not have any further motions in limine, Your Honor.
Defense, I believe you mentioned you have some motions?
Yes, Your Honor. We move to exclude any mention of the condition of the lifeguard chair. By way of quick background, an incident occurred at the Zeta Lambda Nu fraternity in which Ms. Denning jumped off of a lifeguard chair. However, in the complaint, there are no statements regarding the condition of the chair or anything otherwise. The issue at hand before us today, as asserted in the complaint, is if Andre Dornberg instructed her to jump from that chair when and if she knew she was drunk. And so if the evidence is allowed of the condition of the lifeguard chair, it has a high probability of confusing the jury of the issue here at hand today.
Plaintiff response?
Yes, Your Honor. Although it is not pleaded exactly in the complaint, we do think it is very important in order for the plaintiffs to prove their burden here today to show and prove the condition of the lifeguard chair. Whether or not she was intoxicated and was told to jump off really is important in order to know whether or not the chair was dangerous in itself at first. And here, by way of background, Mr. Dornberg, through depositions, has already conceded that he did think that it was dangerous. So we will be using that fact in order to prove that telling Ms. Denning to jump off the lifeguard chair while she's intoxicated did lead to her death.
I'm gonna deny the motion. Any others?
Yes, Your Honor. We move to exclude any mention or statement regarding a previous incident that occurred at the Zeta Lambda Nu fraternity house. By way of background, approximately 25 to 30 years ago, an incident occurred at the fraternity house in which a young man drowned in the pool that was presented at a party. However, the situation is not similar enough to provide notice to the defendants of a dangerous condition, as Ms. Denning herself ended up dying from trauma to her skull. Furthermore, no members of this fraternity were present 25 years ago and would not serve as a fair notice to them.
Response?
Yes, Your Honor. Although in the first incident someone drowned and here someone fell off a lifeguard chair, through the deposition of Mr. Dornberg, we learned that the way the pool was set up was exactly how the pool was set up at the previous party, and therefore it created the same risks and dangers associated with the party here incident today. And in regards to opposing counsel's second argument, although the members are not here today and at trial, who is at trial is at the Zeta Nu fraternity, and they only act through its members, and therefore they have cumulative knowledge of what their members have done before and know how to make their party safer based on previous events.
Remind me, what was the cause of death in the incident 25 years ago?
Drowning, Your Honor.
And the cause of death here?
Trauma to the skull.
Do we have any sort of, do you have any evidence or facts from that case that explain what caused the drowning?
From my understanding, Your Honor, the facts that presented from the case from 25 years ago was that when Sergeant Alexander Bell arrived on the scene, he had found a young man who had passed from drowning in the pool. Unlike this incident, where Kay Denning's death resulted in trauma to the skull, they are much different situations.
Yeah, I tend to agree with defense that I don't completely see the relevance here or notice in this case. However, I'm going to reserve ruling to see if you're able to lay the proper foundation to get that in first. Any other motions?
None, Your Honor.
Okay, seeing none. Plaintiffs, are you prepared to move into opening statements?
Yes, Your Honor.
Okay, go ahead. Hold on one moment, so I'll start timing this. Okay, whenever you're ready.
Poor planning equals poor results. On May 24th, 2019, the fraternity Zeta Lambda Nu The defendant, in this case, threw a party. And the facts and the evidence that you'll see today will prove to you that because of that fraternity's poor planning, Kay Denning was allowed to climb up the top of a lifeguard chair and slip and fall to her death. Back in May of 2019, Kay Denning was a college student. She had goals, she had dreams, she had her whole life ahead of her. And on May 24th of 2019, Kay and her friend Christina were walking back from dinner at a Mexican place on campus. They were walking along Fraternity Row, along the defendant's property, when someone started yelling at them. So they turned around to see who was yelling at them, and they saw the defendant's house. They saw a beach, they saw a pool, they saw sand, they saw a lifeguard stand. And on top of that lifeguard stand was Andre Dornberg, the defendant's treasurer, the person that was yelling at Kay and Christina with a megaphone. So Mr. Dornberg comes down that lifeguard stand, and Kay and Christina quickly learned that he wanted them to come to the party. So they chatted a bit and they exchanged phone numbers. And Kay and Christina did try to go to that party, but they didn't get in. Kay forgot her ID, but it wasn't the end of the world. They just went to another party. But the facts and the evidence you're gonna hear today will prove to you that Andre Dornberg didn't like that. So while Kay and Christina are at the other party, Andre starts badgering Kay. He badgers her again and again and again. He wanted to know where she was, if she wanted to go swimming, if she was coming to the party. So Kay shows up, and Mr. Dornberg meets her and takes her to the backyard. And then he tells her to meet her in the front of the house while he went upstairs and changed his shirt. So Kay goes to the front of the house to wait for Mr. Dornberg, the same front of the house that she saw him yelling from the top of the lifeguard stand earlier in the day was at. So Kay gets to the front, she climbs up that lifeguard chair, and she falls headfirst into the water. She dies. And because Kay died, her estate brought this case, which means that we're the plaintiffs and we carry a burden. The burden we have to meet is a preponderance of the evidence, or more likely than not. More likely than not that the fraternity was negligent. More likely than not that the fraternity did something wrong. So let's talk about the testimony you're gonna hear today that will prove to you that the fraternity did something wrong when they put an 8-foot lifeguard stand in a 2-foot shallow body of water at a party where they knew college students were gonna be drinking. First, you're gonna hear from Christina Bloom, a lifelong best friend of Kay Denning. Someone who didn't get into the University of Middle Sunshine, but you'll learn, tried to spend weekends with Kay whenever she was able to, just like she was on the weekend of May 24th. Christina's gonna tell you that she saw the beach set up earlier in the day when her and Kay were walking by the house. She saw the pool, she saw the sand, and she saw the lifeguard stand with Mr. Dornberg on top. But what she didn't see were any cones, any caution tape, or any warning signs. And when she went back to the house later in the night looking for Kay, she saw the same thing. She didn't see any cones, she didn't see any caution tape, and she didn't see any warning signs. She didn't see anything that would have prevented college students from being able to climb to the top of that lifeguard stand. And then we're gonna call Sergeant Alex Bell, a 30-year veteran of the University of Middle Sunshine Police Department. Someone who went to Ranger School. Someone who trained under one of the best officers to come out of this department. And because of that experience, he was promoted to sergeant and he got his own patrol. So when Sergeant Bell got to the scene, he knew what he needed to do. And he began his investigation. He interviewed 3 witnesses on the scene, all of whom you're gonna hear from today, and he inspected the scene. He saw the beach, he saw the sand, and he saw the lifeguard stand. But he didn't see cones, he didn't see caution tape, and he didn't see warning signs. He didn't see anything that would have prevented college students from being able to climb up that chair. And after we rest our case, the defense will put on their case, and they'll call witnesses. You're gonna hear from Andre Dornberg, the defendant's treasurer, the person who planned this party, the person who brought the lifeguard chair that was only supposed to be a prop that nobody was supposed to use, who invited Kay Denning. And you're gonna hear from Courtney Perez, the person the fraternity brought in to help with the party planning, because they've used her before and they trust her opinion on safety. You're gonna learn that she told Mr. Dornberg that chair should never have been at the party. And while these witnesses are testifying, we want you to think of 2 questions and see if they can answer them. 1, did the fraternity really think it was a good idea to put an 8-foot lifeguard stand in a 2-foot shallow body of water at a party where they knew college students were gonna be drinking? And 2, if the chair was really supposed to just be a prop that nobody was supposed to use, did they tell anybody? And we're confident that at the end of this trial, after you've heard all the evidence, after you've seen all the testimony, you'll find that the fraternity was negligent. That the fraternity was negligent when they put an 8-foot lifeguard stand in a 2-foot shallow body of water at a party where they knew college students were gonna be drinking and did nothing to make it safe. Because poor planning equals poor results.
Thank you. Defense?
You're only responsible for what you can control. And on the night of May 24th, 2019, that's exactly what happened for Zeta Lambda Nu fraternity. College fraternities are often misunderstood, but at the end of the day, they're organizations that help build future leaders. They do this by providing many networking opportunities and leadership roles for their members. They also help raise money for charities and give back to their community. Throwing parties is a part of college fraternities. Because they happen often, they have a lot of experience with how best to execute these parties. And their main priority is to keep the party safe. And that was no different for Zeta Lambda Nu. And that was no different for how they went about the event that occurred on May 24th, 2019. But the story begins much earlier than that night. It starts weeks before the party occurred. Today you're going to meet Andre Dornberg, and you're going to learn that he got the idea to plan a party for his fellow classmates. He wanted to plan a party that was fun for everyone to enjoy because the semester was coming to an end. After weeks and months of hard work, he wanted to create a space on campus for people to come to enjoy. But he wanted to stick with the principle of keeping the party safe and planning it properly. He did this by hiring an experienced party planner, Courtney Perez. She was well known on campus because she was hired by many organizations throughout her time to plan parties and to do so safely. Once Mr. Dornberg and Mrs. Perez began meeting, Mr. Dornberg expressed 2 important things to Courtney Perez. The first important thing he emphasized to her was to ensure the safety of the party setup. The party setup was composed of a tiki bar, sand, a makeshift pool, and a lifeguard chair. The pool itself was no more than 2 to 3 feet deep, and you will learn there were some concerns with the lifeguard chair. A lifeguard chair that was meant to be a prop. It was not meant to be used, but just in case, the fraternity took precautions. They tied sandbags to the bottom of the lifeguard chair to secure it, and they placed it in the water So just in case somebody happened to climb it, and if they were to fall, they would fall into the water rather than the concrete. The second most important thing Mr. Dorenberg stressed to Ms. Perez was to follow the campus rules and the law. Mr. Dorenberg stressed over and over again that only those 21 and over would be permitted into the party. To ensure this happened, Mr. Dorenberg and Mrs. Perez created a sign. Not just a sign, a 5 to 6 foot sign that was hung over the door to the entrance of the party. They also passed out invitations to organizations on campus. They passed out an invitation to Miss Denning's sorority, Chi Pi. This invitation stated that only sorority sisters in good standing and of legal drinking age would be permitted to enter. Zeta Lambda Nu did what they needed to do to ensure the proper safety precautions were followed. They did what was in their control to ensure the party was safe on May 24th. The plaintiff brought this action against Zeta Lambda Nu, therefore they bear the burden. They began carrying that burden the moment they walked through that door, and they will continue carrying this burden throughout the rest of the trial. Their burden is to prove by preponderance of the evidence that Zeta Lambda Nu was negligent. They must prove each element of negligence by more likely than not. These elements are, even though Zeta Nu had a duty, they breached that duty by failing to properly supervise Ms. Dennings, and they caused the injuries that occurred on May 24th. If you find not that just one of these elements have not been proven to you, that you have just but a little bit of doubt in any way throughout this trial, you cannot find Zeta Lambda Nu liable. The plaintiff will bring several witnesses throughout the plaintiff will call several witnesses. They will call Christina Bloom and Sergeant Alex Bell. And once you hear their testimony, you will see that the plaintiff cannot meet their burden, because the evidence will show Zeta Lambda Nu could not control Kay Denning that evening. The evidence will show that Kay Denning and her best friend Christina Bloom were aware of the risks. They knew they weren't 21 at the time and couldn't enter the party. They saw the beach set up multiple times that day. They went to that fraternity house 3 times. They knew the water was no more than 2 to 3 feet deep. They saw the lifeguard chair in the water. They knew the risks. Kay Denning acted anyway. Members of the jury, while you're listening to the plaintiff's witnesses I mentioned earlier, I want you to ask yourself 3 questions. First, did anyone force Kay Denning to drink that evening? Second, did anyone force Kay Denning to climb to the top of the lifeguard chair? And third, did anyone force Kay Denning to jump off of the lifeguard chair? You will find the answers to these questions are no, no, and no. We, the defense, will also call 2 of our own witnesses. We will first call Courtney Perez. She will explain her extensive experience as a party planner on campus, the go-to girl for organizations when they want a party properly planned. She will testify as to her and Andre Dorenberg's conversations and implementations of safety precautions, and how Kay Denning acted by herself that evening when she jumped off the lifeguard stand. You will also hear from Andre Dorenberg himself. He will explain how seriously he takes his role as then treasurer of Zeta Lambda Nu and now president. He will walk through the events that happened on May 24th, and he will explain that he did not think it was a good idea to dive off that lifeguard stand, and he did not agree with it. At the end of this trial, my co-counsel will come before you. At this point, you have heard all the testimony and seen all of the evidence. We are confident that when you apply the law, as it will be explained to you, that you will find there is only one verdict supported by the law and supported by the facts. And that is finding Zeta Lambda Nu not liable. Because you're only responsible for what you can control. Thank you.
Thank you.